And welcome to this episode of the Capitalized Life and Retirement Show. I'm your host, Matthew Johnson, president and owner of Johnson Wealth and Income Management, a retirement income source located in Clear Lake, Humboldt, and Ankeny, Iowa. Well, how are you today? Hope you're taking a little bit of time for yourself, and welcome to today's program. You know, as a financial advisor, as a fiduciary, I get questions that are kind of broad and specific all in the same time. All in the same way, I guess. And the questions are like, when's the best time to apply for Social Security? What's the best kind of life insurance to have? And though there are answers to those questions, and they are very cliche, very rhetorical, one of the questions that I do get, which does have a great deal of importance, and there's absolutely no humor in it whatsoever, is what is the most important legal document that a person can have? And so today I'm going to be answering that question. This is a document that is so important to you that it could save you, it could save your family, it could save your assets, it could save a tremendous amount of heartache and heartbreak. And so you got to have one of these, in my opinion, as a financial advisor. Now, if you're brand new to this program, I just want to give you a warm welcome, and I want to encourage you, go to our website. If you've been looking for a place that's practical and down to earth, a place that you can go and learn about financially relevant topics that are going to help make you more successful in your quest to get to retirement and getting through retirement. Who cares if you get to it? You want to get through it, and you want to do it living the life that you want. You want to get through retirement enjoying and not fretting and worrying. Well, the website, johnsonwim.com, has a whole host of resources and information. There's video, there's past radio shows, there's white papers for you to read and to learn and to become more financially literate. I also encourage you, if you're more of a book reader, get a copy of my book, The Capitalized Retirement, something that's available to all major book resellers, something that gives you practical guidance, it gives you a path to follow, to be able to understand that as you get closer to retirement, you get into retirement, your priorities change. And as your stage of life changes, so should your asset allocation. And it's something that to really challenge the modern day way of thinking about how you invest your money. So what could this all important legal document be? Well, it is something that I know you've heard of. It's maybe something that you even used with your own parents, but it's something that you need. And I would argue regardless of your age. I don't care if you're 39, if you're 99, you need this document, and it is the financial power of attorney. Now, it goes by a couple of different names. It goes by durable power of attorney. It goes by financial power of attorney. But one of the very first things that I want to start out with today is the fact that people hear power of attorney and they start to have heart palpitations because they think, well, whoever this person is, number one, I don't even know who I would appoint. And number two, when I appoint this person, well, they could take full advantage of me. And that's where we want to kind of go back and describe for you that a power of attorney is, yes, it is allowing you to elect and to select an individual or individuals to advocate for you, to be your financial fiduciaries, to pay your bills, to take care of you financially speaking, yes. But the reality is that you're in a position where those powers that you were shifting to them are limited. In other words, if let's say that you had a son and he was the financial power of attorney and you had $1 million life insurance, he can't, as the power of attorney, just call up the insurance company and go, hey, I want a beneficiary change form. I'm going to be making myself the primary beneficiary on that $1 million life insurance policy. There's really not an insurance company, a bank, a brokerage house, a financial advisory firm that would or legally should take any kind of instructions like that. So that financial power of attorney is there to just do the basic things to keep you in compliance with the law, keeping your property taxes paid, keeping your income tax paid, keeping your bills paid. taking care of required minimum distributions. These are individuals that, as an advisor, I rely upon every single day so that I can take care of you, my client. You see, powers of attorney are designed for the living. They're not designed for the dead. And so as long as you're alive and you're my client, if you're no longer competent, you cannot make financial decisions and make good, sound financial decisions, that individual that you have elected, or individuals, that's the person that I rely upon to communicate with, to make certain that they understand, hey, this is what's going on, and we need to make a decision about this over here. And we live in a world in which that's what you want. You see, we live in a very litigious world, yes, but we live in a world that has changed. No longer are decisions being made, my friend, with a handshake and a verbal agreement. It's even difficult for spouses. If you're, say, a husband and you get into a car accident, your wife is going to find that she gets pushback from the bank when she's making decisions. And even if you live in a small town bank and they want to help her, even if as a financial advisor, I love you both and I want to take care of you. The reality is legally, I can't even do that without her providing me the power of attorney that is the permission slip to say, yes, this woman here can make decisions financially for me. Okay? Now, with that being said, I do want you to know that this is where we have to understand that the POA is a multifaceted form. In other words, not only do you have the primary or primaries, yes, you can list more than one primary POA. And in that instance, generally speaking, and I'm no attorney, but generally speaking, they now have to work in agreement. Okay, we've seen this happen multiple times where maybe it's a couple of sisters, maybe it's a couple of brothers, maybe it's a brother and a sister, whatever the case may be. But they have to work in unison, they have to work in agreement. Now, but the question becomes, generally, the design is there's an individual as the primary. So what happens if that individual, let's say you're married and that individual is your wife? Is it ever true that you ever go anywhere together in the same automobile? And the answer is probably yes. You go out on a dinner date, you go to church on Sunday morning, and you could be both hurt in a car accident. So what happens in that instance? Well, in this case, this is where you now have what's called the backup POA or the secondary, okay? And the secondary is the individual or individuals that are now going to be invoked, and they're going to be brought into place in the event that the primary is unwilling or unable to serve. And that's how it legally goes. And so can you have a tertiary? Can you have a third one? And the answer is absolutely yes, you can. So is it likely you'll ever get to number 3? And the answer would be statistically very improbable. Does it happen? I'm sure it does. And so this is the reason why I encourage clients, hey, if you're married, make your spouse, if you trust them, to be your primary POA, and then you have, your son or your daughter that you feel is the very best financially to make decisions for you. You don't want a child who has a history of mismanagement of funds and doesn't know how to handle money as your power of attorney. You want someone who is trustworthy. And so they're going to be secondary. And then you can list someone else, maybe a grandson, maybe a friend, maybe a granddaughter, whatever, another child that you would consider to be the primary. Or the tertiary, the third in line. Now, there's another facet behind the POA that we want to be thinking about, and that is the fact that there's really technically 2 different designs. One is called the springing POA, and the other one is called the immediate. Now, the springing is not as popular as it used to be. The springing was really the only power of attorney that did exist for quite some time until the immediate came into place. But can you still get them? And the answer is yes. And what is the advantage or disadvantage? Well, I don't see much of an advantage to the springing POA. Primarily, what happens is if, let's say, something has happened where your family feels that you're no longer competent, you're no longer able to make financial sound decisions, that family member, whomever they may be, before that POA can be invoked, has to take you before 2 different doctors. And those doctors have to assess you, and they have to both agree that you no longer can make sound financial decisions. Well, here's the problem with that. Number one, it does create a great deal of debate. Number two, it is getting very unpopular with doctors. Doctors in the medical field in general don't like it because they feel as though it's more of a malpractice lawsuit waiting to happen. Like a child is going, you're calling my mom nuts, and she's not nuts. She's as sane as anyone, and it's okay for her to hide the hot dogs in the bread in the bread box. That's the liability that they're trying to get away from. And so as a result, over the course of time, it has become more and more progressively popular for individuals to adopt the immediate power of attorney. And what that means is that you sign it, you execute it, and it's in force today. It doesn't mean that it's being utilized. It doesn't mean that it's being used. It just means that it is actually available for use. And so whenever that day does come, and hopefully it doesn't, but if it did, you had the stroke, you had the car accident, you had the heart attack, whatever the case may be, that power of a document is there, it is in force, it is ready and waiting to be deployed. And that's a very nice thing. You see, when things happen and medical emergencies occur, emotions are going to run high. And that is the last time, in my opinion, that you need to be taking additional time and adding additional steps for your family to take care of you. And so as a result, the immediate POA is what I generally will advocate for, unless, of course, there are unique circumstances that are dictating otherwise. Now, the third facet to the POA, and this is the one that I'm sure some of you have said, well, all of this is just elementary, dear Watson. I already have the POA. This is not a big deal. Like I've just wasted already, 10 minutes of my life listening to this. Well, not so fast. I want you to really take the time to listen to this last part. And that is that many of you have financial powers of attorney. You've already got them printed. You've already got them executed. They're already in the safety deposit box. And that's great. I'm happy for you. But the reality is that they are old and they are out of date. And before you get all uptight here, hear me out. You see, there is technically, as far as I'm aware, no legal precedent that says that a financial power of attorney ever goes out of date, that it ever expires. But the reality is that with all the financial institutions that we work with in everyday life now, whether it's the bank, the insurance companies, the brokerage wirehouses, whatever it is, well, these institutions legally can decide whether or not they want to accept your family's POA. And so as a result, I have coached and trained and encouraged my clients to get their POAs done every 5 years. And the reason for that is this. If you've got a POA that was written back in 2003 and executed, there technically is no problem. There is no issue with that if the same individuals are still the same people that you want as your powers of attorney. That's fine. But the reality is that the bank is not likely to accept that. So if you want to do yourself a favor, you want to do your family, your spouse a favor, make certain that both of you, or if it's just you are getting that power of attorney up to date and freshened about every 5 years. Does it take a little bit of time? Does it take a little bit of effort? Does it take a little bit of money? And the answer is absolutely. Now, I provide POAs absolutely free of charge to my clients. But if you're not one of my clients, you're probably going to have to pay a professional, an attorney, or some sort of a legal entity somewhere online to get that power of attorney. But is it worth it? Is it worth it to keep it up to date and to make certain that if something does happen, your family isn't getting a bunch of flack and they're not being stalled and delayed in taking care of you financially? And the answer is absolutely, I think so. So go do the right thing. Get yourself a power of attorney. Get your spouse a power of attorney. Think about the primary, the secondary, the tertiary. Make certain that you're keeping it up to date. Make certain that all of your POAs understand that they are not required to serve, but you would like them to serve. Make certain that they have a copy of that POA. I remember when something happened to my mom and I didn't have a power of attorney. She had never given it to me. She was a very private person, and I get that. I appreciate that more than the next guy, just as much as the next guy. But the reality is that I spent days trying to find where that power of attorney was, and she was of no help because she was in the hospital. And so in this case, it really can put you into a tough bind as a child or a spouse when you're trying to take care of your family. Remember, we don't live in a day in which financial decisions are being made with a verbal agreement and a handshake. Today, things have to be legal. They have to be documented. So go do the right thing. I'm Matthew Johnson. Thank you so much for listening and watching. And remember, it's up to you to make today a great day.